Well, good morning, everyone. All right, thank you for being here. My name is Greg Carlson. I'm the president of NYARM, and I welcome you to this very important seminar. And as you saw, we have a little light breakfast and coffee, and after the seminar we'll have some lunch and we'll mingle and talk. I want to get the program get going. So after the seminar, I do have some legal or legislative announcements to make, very small, not too many. It's budget time, so they're busy doing budgets. So without any further ado, I'd like to introduce NYARM's executive director, the talented Margie Russell.
Thank you, Greg. Good morning, everyone. Our topic today, which is utilizing the AIA General Conditions documents, is of course relevant right to this moment because everyone is starting construction. And so whether it's a job big or small, the speakers will explain to you the pitfalls and the importance of it. When I was running properties, I always had a contractor more often than not say to me, I never sign a general conditions clause or allow it in my contracts. And you will hear today why that is detrimental to everyone. We all play pickup basketball or such, and no one doesn't go by the rules. You don't have to sign a piece of paper, but you play by the rules. And people think that they don't have to play by the rules. And by having the signed piece of paper puts everyone in the mindset that they will play by the rules, because you just can't have everyone going by a different set of rules. What I'm going to ask is that each of the speakers give us 1 minute or so on themselves and on their company before they speak. And my co-moderator is Scott Silberman from SMS Engineering, and he will introduce himself in a moment. Yes, you can take that microphone.
1, 2, 1, 2.
And the other speakers today, CJ Berger with the law offices of CJ Berger. Okay? Edwin McCoul, certified CIC, McCoul and Associates, president of McCoul and Associates. Stephen Varone, registered architect, AIA, with Rand Engineering and Architecture, the founder of Rand Engineering. And Phyllis Weisberg, attorney with new company, we know her from the previous company. She's with Montgomery, McCracken, Walker, and Rose. Okay, so Scott, if you would introduce yourself, and we'll take it away.
Yes, my name is Scott Silberman. I am the president of SMS Engineering. Our company primarily does a lot of facade restoration work and consulting, which is very familiar to most of the people in this room. In addition to that, we also do a lot of engineering work on large construction projects throughout the city. On any major structure that you see now, the Brooklyn Bridge, the George Washington Bridge, the Henry Hudson Bridge, the Verrazano Bridge, all those major construction projects, we've been actively involved in designing all the scaffolding and a lot of the safe work procedures that a lot of the contractors employ. In addition to that, I personally have been qualified as an expert witness in both state and federal courts for a lot of premises liability type of accidents, as well as construction labor law. The construction labor law is basically one of the main topics we're here to talk about today, about trying to protect the property managers, the building owners, against a lot of the pitfalls that occur during most of the construction projects that occur at your properties. So, thank you. Margie, who's next?
My name is Phyllis Weisberg. I'm a partner in the law firm Montgomery, McCracken, Walker, and Rhodes. And I practice real estate law, and a large part of my practice is the representation of boards and co-ops and condos. And in the course of my work, obviously, we get involved in a lot of construction projects. projects handled in many different ways in various buildings that we represent. Sometimes the construction project is handled by a purchase order. I've seen roof replacement done by a purchase order. I've seen jobs handled where there is a contract and it's prepared by the contractor. I've seen form contracts prepared by the architect or the engineer and never vetted by a lawyer. That's all well and good if the job goes fine, it goes on, it's on schedule, there are no defects, there are no issues, there are no injuries. But in the real world, all those problems occur from time to time on these jobs. And so we lawyers who are paid worriers, we're supposed to worry about everything that can go wrong, really believe that at the outset of a job, you should have a lawyer involved with the project. Now, some of our co-op and condo boards say, well, why do we need to spend the money? And the answer is spending a small amount of money up front will protect you when the job goes bad. And it will give you rights that you might not otherwise have. Typically, that's done through the use of AIA forms as a base. The AIA forms are authored by the American Institute of Architects, and while it is supposed to present a basic industry standard, it is the American Institute of Architects, and therefore there's a lot in the contract, in the forms, that protects architects a lot better than it protects owners. And so you have to look at these documents carefully. I've given you a handout that has some of the general philosophy of the AIA in preparing these contracts. It talks about their drafting principles and their revision principles. The AIA comes out with these forms every 10 years. There's a revision every 10 years. So, of course, if there are major changes in the law in the interim, they're not going to be reflected unless your attorney puts it into a rider. And I've heard it said, and I really do agree, that anybody who enters into an AIA contract without having a rider put on it, in other words, the attorney looks at it and says, fine, no rider, no modification needed, potentially malpractice for the lawyer, because each job is different and there are different risks involved. The risk in a boiler replacement project is different than the risk in a facade project on a 50-story building. And you have to account for that in various ways. I do think the AIA form is a good start, but I do think it needs a lot of revision. Among the issues that you need to look at is, first of all, how does the AIA form line up with the specifications that have been prepared by the architect or the engineer? Some architects and engineers prepare specs excuse me, that deal purely with the technical aspects of the job. They prepare the drawings, they specify what materials are going to be used, and things like that. Other architects and engineers actually venture into the legal areas and put things in the specifications that are really legal issues. They may have indemnity provisions in there. They may put in provisions relating to insurance. They put in other items that have legal consequences. And so actually we advise our clients, before the bid package is sent out, let us as attorneys vet it to make sure there's nothing in there that would inhibit what we could put in a contract later on. Or, for example, if the bid package goes out and there were no liquidated damages provided for in the specifications, we will ask the client, do you want liquidated damages? And you can argue whether that's a good idea to have in the contract or not. But if you want it, it really needs to be in the bid package, because once the contractor bids, if you then hand them a contract with liquidated damages and they say, well, that's not the job I bid on, you're going to end up in a negotiation that's really, you shouldn't have had to be involved in, and it may open up other things. So you need to be careful about what's in the specifications. And then you have to see how that lines up with the AIA contract. In the handout, we talk about what I think are the two main contracts, or the two main contracts that I get involved with. One is the A101, which is a longer form of contract, and it's accompanied by the A201, which is the general conditions of the contract for construction. And sometimes we use an A107, which really combines the two documents in a simplified form, and it's generally for smaller projects. Remember, these documents are prepared for all kinds of construction contracts, including new construction. It's one size fits all. So you have to look at these contracts, keeping in mind what's practical for the kind of job I'm doing. It's $50,000 worth of exterior work. Do I really need a 90-page rider with all kinds of qualifications? And the answer is no, you don't. You have to be practical, but you have to make sure that it covers the issues. Some of the important things that I think need to be looked at in the AIA forms and considered are issues such as dispute resolution. Until the 2007 edition of the AIA form, the AIA had a dispute resolution provision which had what I think is one of the more horrendous provisions that was out there, which is that if there's a dispute and there's an arbitration as a result of the dispute, you couldn't join parties, which meant that if a job went bad and there was an arbitration, the owner could not assert claims against both the contractor and the architect in the same forum, which meant that you could arbitrate against the architect who says, not my fault, it's the contractor's fault, and you, the owner, lose, and then you arbitrate separately against the contractor who says, not my fault, the specs were lousy, and you could lose again, so you were without a remedy. Fortunately, in the 2007 edition, the AIA recognized that problem, and there is a better provision in there, but it's not great. Among other things, there's mandatory mediation before you go to arbitration or litigation. Sometimes an owner needs to get to court quickly. You might need an injunction. You might need some other remedies. And so we typically delete the entire dispute resolution provision. Now, you should talk to the lawyers for the buildings that you manage or represent to see what their view is, and it may depend on the job, and it may depend on the cast of characters too. But generally, that provision must be looked at very closely. There are provisions relating to insurance in here. The limits need to be set someplace. If they're not in the specs, then they need to be in the contract. But there are provisions relating to insurance that are not dealt with in the AIA contract. For example, there's something called an employee exclusion. And if it's in the contractor's policy and the owner is an additional insured and there's an injury sustained by an employee, there may be problems if all employees are excluded under the policy. So you need to have that deleted. It's not in the AIA. It's why you need your attorney to look at it. And I might add that if it's a big enough job and the risk is potentially big enough, very often it's a good idea to have your insurance people take a look at it as well, both as to the limits and as to the types of coverage. There are things like owner's responsibility to provide a survey. Well, if somebody's doing facade work, if somebody's replacing windows, if somebody's doing a roof, they don't need a survey. So you want to delete that provision so the contractor can't someday, when you get in a dispute, point to that and say, well, you never gave me a survey, and even though it's irrelevant, it's technically in violation of the agreement. So you would take it out. There are things about hours of work. When you're working certainly in the buildings that I represent, you're working in an occupied building. Again, not new construction. And there are certain quality of life issues that become important that are not dealt with in the AIA form that you would want to deal with in a rider. Sometimes some of those issues are already dealt with in the specs. Again, somebody needs to look and see if the specifications do contain enough information about those particular issues. There are provisions on when you can terminate the contract, what the conditions are, and whether the contractor is entitled to overhead and profit on termination. Those need to be looked at very carefully, and we recommend strongly modifying them. There are things that lawyers worry about, which is what if there's an inconsistency in the documents? You have an AIA contract, you have a bid package, you have the bid, you have drawings. What if there are inconsistencies? What will govern? And we try in the riders that we add to our AIA contracts to add something in there to say if there's an inconsistency, then this document will take precedence over a second document, and we enumerate how all the contract documents line up so that you can avoid a dispute down the road. There are things in the AIA contract that need to be modified. Unless it's a unit price contract, if it's a fixed sum for exterior work, for example, and there's an estimate of the number of linear feet, but it's an all-in contract, then you want the contractor to represent that it is not relying on the measurements that the architect or engineer provided, that this is the all-in price, and if it turns out there's a deviation in the number of linear feet, contractor eats it. I actually had a dispute a few years ago where, unfortunately, the engineer had done a less than stellar job in the specifications, and it turned out after the fact that there was a question as to whether 15 floors of the building were included in the work, and it was exterior caulking and repairs. And we had a provision in the contract that talked about the contractor had done all the measurements and would be bound by them. And ultimately, the contractor, who I guess was getting hurt on the job and tried to argue that he didn't have to do those 15 floors, we pointed to that language in the contract, we pointed to language in the specifications, and ended up working out a deal essentially with the contractor, recognizing there was an ambiguity, where the contractor provided all the labor for those 15 floors, and the owner was only responsible for the additional materials. But it was that provision that helped us attain that position and work it out. And it was a contractor who worked on the building for a long time, and the owner didn't really want to, be that harsh with the contractor, but gave us the ammunition. There are many, many other issues that need to be dealt with again, looking at the specifications of the job, the nature of the work, how risky is that, what's the impact on the ongoing operations of the building. And so I think it's very important that you use these contracts. I know they're not, given the size of these projects, the amount that it costs to have an attorney review the specifications, prepare the contract, is really insignificant, and hopefully it saves you a lot of headaches down the road. Thank you.
One thing I've come across a lot is that the one thing that I come across a lot with a lot of property managers when they have a lot of buildings is I say to them, hey, you got to have a contract. But a lot of them say to me, I have insurance, and they name me as additional insured. Why do I need a contract for? So I don't know if you want to.
Okay, well that's sort of along the lines of my purchase order, for a contract. When you're named as additional insured, that gives you some but not a lot of protection, as I mentioned. It may not be the right insurance. It may not give you notice if the insurance is canceled. And I might add that one of the things you have to worry about is if a contractor names you as additional insured, and then they never give their carrier notice of the claim, there may be a basis for the carrier to disclaim on that. So relying on the contractor's coverage in and of itself is not enough. One of the things we put into our AIA contract riders, is that to the extent the contractor is not covered by insurance, there's an indemnity. In some cases, some of our clients want a bond posted because maybe the contractor doesn't have assets, so the performance bond might help, although that's going to help you more with completion of the job as opposed to the liability issues. But there are so many issues that need to be dealt with, and I think just relying on the contractor's insurance, I mean, how do you know if they're completing the job timely? How do you know if they're staffing it well enough? I've seen jobs drag on interminably. How do you deal with defects? What kind of a guarantee is there? What kind of warranty? Just getting an insurance certificate doesn't do it.
Good morning, everyone. My name is Stephen Varone. I'm president of Brand Engineering and Architecture. We're an approximately 80-person firm in New York City that specializes in working with cooperatives and condominiums on restoration, repair, and upgrade work. Our work ranges from engineering through facades, through mechanical engineering, structural engineering. So our typical project is a capital improvement for New York City residential cooperative or condominium. So we deal with these types of issues every single day. And Phyllis made some great points about the limitations of an AIA agreement using the AIA documents. And I guess I'm coming at it from the other side of the day-to-day work environment, meaning we're asked to put together design projects for clients who often have a very wide range of what their professional team is. You can go from a large complex on a multi-million-dollar job where there's clearly going to be a lot of involvement from legal, there's going to be heavy involvement from property management, all the way down to something where it's a $100,000 project, and not only is there no money for a large team, but there's no time either. So we tend to get involved after the contractor. We're the first firm that gets involved because if you need a permit, you need to have an engineer or an architect. Someone has to file something. So when we have to file something, okay, we're involved, and we might as well have that document to put out for bid. So when we put together a bid package, as Phyllis mentioned, some of the firms, engineers and architects, will have quote-unquote legal clauses and phrases in their specs. The reason RAND does that is because I have no control over what the property manager is going to do with that bid package once I provide it. So we need to provide something that at least has a basis for the things I understand that they would need to want to protect themselves on. So that it's not just out there as just point these joints or replace these bricks or replace this boiler, and all the legal just gets left up to whatever's on the contractor's proposal himself or purchase order. So we will propose what we understand to be the industry standard clauses and expectations of all the parties. And along with that, the AIA documents, the AIA A101, which I prefer over the 107 because I think it answers more questions and it's not really hard for us to put it together. We will use that as our basis because while understanding is not a perfect document, it is the assumed standard in the industry, meaning the way that Brand runs its projects and the way that most contractors will run their jobs are under the expectation that, well, if we have some kind of dispute, what does the AIA say about it? And that's kind of where we look for dispute resolution, as for one thing. And the reason why that's so common as our assumption is because Phyllis's firm does a very good rider, and we love attaching notes to our, it makes it stronger. It makes it stronger from the owner's interest. They point out some problems with the AIA. But it may be a different rider than what another firm would have sent me, and a different rider from what another firm would send me. So in order for me to have one standard of what I follow, I will follow the AIA standard with certain things that I know that I want to modify, like I take out the provision for lost profit. I will cross out phrases that say the contractor is paid as soon as he delivers materials to the site, unless it's something like they purchased a boiler and they really have to lay out a lot of funds. But if someone's delivering bricks to a site, the cost of that is so incidental to the work, to the labor, that you can, giving them $20,000 for bricks and then having them disappear off the job site, you don't really have, you have bricks. You know, you don't have any completed work. So my point is that we will have our quote-unquote legal phrases in our general conditions. We will offer to draft for the owner a basic AIA agreement, but then we will say to the owner, please have your legal counsel review this, modify it as they need it, put their rider together so that we can then have a final version. But I have no control over whether the property manager says, who has time for that, or just send it out. So I try to use the wisdom I've gained from the law firms who have done these for decades and put some clauses in as suggestions, but we say, please have counsel look at it. So my point is that the AIA establishes that standard in a lot of places, and whether we realize it or not, that's how the industry functions. So, for example, on time completion of a project, as Margie pointed out a few points to focus on. One of them being time completion. What does that mean? When you're establishing a contract for time completion, it means substantial completion of the work. And what does that mean? It means something different for new construction than it does for repair and upgrade projects. But essentially what it means is that the project or the work can be used or occupied for its intended purpose. Meaning if you're doing a gut renovation of an apartment, they're living in it now. There may be some touch-up to do, there may be a slow drain somewhere, but it's effectively being used for its intended purpose. And at that point, you would have a punch list that would need to be addressed before you get to final completion. But for idea of what contract time means, it means to get to substantial completion. All right? Phyllis mentioned damages. Liquidated damages in the time completion. I'm a big fan of liquidated damages, not because I want to be unfair to contractors, it's just because it's a cliche, but it's a cliche because it's true. If a contractor has two projects on the same street with the same timelines, and the work is exactly the same, one of the projects has no damages and the other one has a damage clause, human nature, which one does he tend to finish first, all things being equal? So if you're the owner and you want it to be finished at the earliest possible time, have a damages clause. My understanding of what has to be done on the damages clause is that it has to be actual damages and not a penalty. Can't be because courts strike it down when it's just to be punitive as a penalty, correct? So it has to be actual damages, which are easy to prove. If a contractor is late, it means you might have more overtime for your superintendent. You have more engineering, architecture visits, things like that. But you show a number that's actual damages that would be incurred. That's the first thing. Second thing is that the more flexible you are with the damages clause, the more likely the contractor is not to have a problem with it. So the example I would give you is, if we say 16 weeks is substantial completion, we would normally propose that liquidated damages don't kick in until after 20 weeks. And then, let's say for a $250,000 project, we may say $500 per day until the work is done. Sometimes a contractor will come back and say, well, then if I have a damages clause, there should be a corresponding bonus clause. And owner will say, well, I don't want to pay bonuses. This is not what I was interested in doing. I'm already paying $250,000. My approach is, no, I love the bonus clause. That's fine. If that's what will get the contractor to accept it, look at the math. 16-week project. After he's 4 weeks late, he starts owing you $500 a day. Okay, corresponding would be bonus clause. If he's earlier than 12 weeks, he starts getting $500 a day as a bonus. I don't know a property manager that would say, oh, this is a 16-week project, disruption and hassle. if this contractor can get it done in 11 weeks, I won't pay him $2,500 extra, right? And honestly, I don't mean to sound cynical about it, but every time we put it in, I've never seen it happen. Never seen him actually. If we make the liquidated damages reasonably this way, the bonus goes so far this way that it's not achievable, right? The other thing, another reason why we give them a grace period before damages kick in is because you don't want to argue about a day here and a day there. Oh, it was Hurricane Sandy, you know, there was no damage to the building, but I couldn't work that whole week. So we put in a grace period that says, look, we know things will happen. By the time damages kicks in, you just relate. It's really no argument. So I love having that in there because it gives us some teeth into paying attention to the schedule. Another thing Margie asked us to talk about was unforeseen conditions. It's such a loaded phrase, unforeseen conditions. What does that mean? It's the great excuse that someone will always dive into as soon as something wasn't as bid or as was, oh, that was unforeseen. How could I possibly have known? If I had lifted up that carpet, I would have seen it totally rotted flooring system. You know, so one person's unforeseen is another person's you should have known, right? But the idea of unforeseen conditions, if it really truly is something that's unforeseen, then the contractor is entitled to additional funds if warranted to correct it. The engineer, the architect may be entitled to additional design fees. The AIA sets out how you deal with that, how you establish, how you adjust time. But really what has to happen is to be determined what is truly unforeseen. One of the ways that you can minimize unforeseen conditions is having a thorough investigation and a thorough spec and all that. The real-world practicalities, whether it's because of time or whether it's because of budget, is you have to stop somewhere, right? So that if you have a structural design where we have to expose a whole ceiling structure and repair it, there's a certain, if we spent, no exaggeration, 300 hours on a design of a $200,000 project, we will find every potential unforeseen condition. But is it worth spending $60,000 in extra design investigation as long as you've got a change order structure set up that's fair to the parties? I'd rather have maybe a $10,000 change order later that we fairly negotiate than spend $60,000 in investigation time to eliminate any possibility of that $10,000 change order. So there's always that judgment of how far you go in the design phase, and then how you lay out your document, so that when it is unforeseen, we agree, yeah, that was beyond what, we couldn't have reasonably foreseen that. You research your potentially unforeseen conditions based on your past experience, but you don't go all the way back. You make certain assumptions about how the building was built. You may be looking at plans that say it was designed in a certain way. And if I say, well, I have to expose 30 beams to confirm that, well, that's really not logical. We can expose a couple and then assume the rest of them all follow suit. All right? What I like very much about the AIA documents and why we teach all our architects and engineers to go about their business and the way our contracts are structured to assume that as the gold standard, as a starting point, is because it tries to avoid getting to broken relationships. Projects will have issues that come up that need to be resolved. I like very much how the dispute resolution is set up. Even before we get, you can debate mediation, arbitration, whether we're going to court and all that. My personal feeling on it, like with RAND's agreements, I usually put mediation first. 'Cause my personal feeling on it is that people get angry first and they get upset, and a lot of times we just talk it through, we figure out the best way through everything. And that's essentially even an unofficial mediation, if you will, rather than have the lawsuits that we all go down a road that incurs costs. But I understand when attorneys say it just creates these unnecessary time-consuming things that don't resolve anything. But my point is that even before mediation, you set up a dispute resolution that establishes the architect in a couple of important ways, I think. First of all, it asks the parties to agree that if the dispute is just about aesthetic effect, then the parties agree, we'll let the architect decide. And it literally, we've been in arguments where the owner says, that's not blue. And the contractor says, that's blue to me. And really our assignment is to say, is that blue? So, because it's just aesthetic. It doesn't affect the structural soundness, doesn't affect the code. And they could argue literally until they're blue in the face. They never agree on what's blue, right? So that's one thing that I find helpful. We have to have the trust of the parties to let us be the dispute resolver in those cases. The other case is if there's a dispute such as the contractor says this was not included in my base bid, and the owner says it was. Our role, and sometimes the owners don't understand this, our role at that point is to step back and kind of represent the architectural industry and to look objectively at both parties' position and say, our interpretation in this case is that either the owner's right or the contractor's right or you're both a little right, and we render a decision. The parties don't have to abide by it, but it's an important step that before you're already up to mediation or arbitration or court, you actually step back and say to the architect, what do you think about this? And what's difficult sometimes for the property manager and the owners to understand is to say, hey, you work for me. You know, how could you give a decision that says the contractor's right here? You can't be saying this. But that's the whole point, to get the contractor to enter into as well and understand we're all going to be, try to be fair about this, and we're going to try and avoid confrontations when we can. They both look to the architect and say, what do you think about this issue? Render a decision. And often the parties will say, okay, I don't necessarily agree with you, but okay, that's it. So I like that very much, that it tries to forestall something going further by asking us to render a decision. Correction of work is something else that's pretty clear in the AIA contracts, and again, that's how I function in my mind about how we run our jobs. A few things I want to point out that's important about correction of work. The AIA talks about a 1-year time period for guarantee, and that's something that normally in a typical brand spec we will ask for. If it's a facade project or a roofing project or a structural project, we'll ask for a 5-year guarantee from the contractor. A lot more than what the AIA talks about. But I like that a contractor will say, we'll stand behind our work for a long period of time. You also don't want to confuse contractor guarantees with manufacturer warranties. And it's important to make sure you have both where applicable. So if you're doing a roof replacement, okay, we're saying the contractor's guaranteeing his work for 5 years, but we also want, hopefully, a no dollar limit manufacturer's warranty from that roofing manufacturer. No dollar limit, meaning if it's a 20-year warranty and it fails in the 19th year, if it's a prorated warranty, you get 1/20th of the replacement cost. If it's a no dollar limit, you get the full replacement cost, even if it's in the 19th year of a 20-year warranty. So very important to have MDL. Also, it's very important to get the buy-in of the manufacturer during the installation, making sure the contractor is a certified installer, making sure that they read the spec, making sure that they're at the site during the installation, because the manufacturers are in business. Part of what they're in business to do is find the fine print in their warranties, how they can disclaim the warranty. So you want their buy-in, that they saw it, that they approved all the details, that they walked through and came up with the punch list, so that you're getting that warranty. You don't want to be left in a place where you don't get the warranty, because if the contractor is no longer in business, the warranty will still cover getting the work done by another contractor. The manufacturer gets to pick the contractor, but still. But if you don't have that warranty, and that means an original issue to you with a warranty number, then you don't have much to go on. So you're going to, and it's not also assumed that the manufacturer's warranty is always more important to have. It's very important to have. Well, we've had scenarios where the contractor wasn't the one that went into business, the manufacturer was the one that went out of business. But we still had the contractor around to kind of make good on problems that came up. So you want both. But correction of work, an important thing to understand here. If the architect did not catch errors that the contractor made, your question is, well, did I pay the architect? Should he have caught that at the level of work that he was doing, right? Meaning, if you had the architect visit the site once a month, and the contractor was working there with 5 rigs every day, and then there's one defective lintel, well, unless that architect saw that lintel on the day he was there, it's probably beyond what his scope was to catch every lintel. On the other hand, if he was checking every single lintel before it was closed up, and then it turns out there was no waterproofing membrane in the lintel, the architect should have caught it, right? The point I'm trying to make here is whether the architect is on the hook to the owner for whether providing additional site services at no charge or helping to defray the cost of the corrective work, that doesn't get the contractor off the hook with the owner. The contractor has a duty to the owner to do the work in accordance with the contract documents, whether the architect catches any of their errors or not. So one of the most common comebacks you get from a contractor who doesn't want to do the right thing is to say, well, the architect didn't catch it. Why didn't you catch it? Stop me before I make more errors. And the owner has to dismiss that and just say, okay, I'll deal with my architect. If I've got a problem with my architect, that's between me and my architect. But you have a duty to complete the work. And it will depend on what your agreement, like I said, with the architect is. So that was something I wanted to mention about correction of work. Margie also asked us to talk about timelines, unrealistic timeline expectations, which is becoming a bigger and bigger issue almost every day, because there are more and more and more hurdles for us to get through in order to do a project. There's so much going on, so much construction going on in the city right now. The governmental staffs are either the same or smaller than they were in prior years. So you have landmarks that's overwhelmed with applications. You have buildings department that's overwhelmed with applications. We've added layers now of site safety approval that has to go through a different division before we can get our permits issued. And I can't tell you how many times we've had a project that not only has no time for an attorney to review a contract, but has no time for anything, no time for permits, no time to do inspects. So you get called by an owner on November 1st saying, yeah, I got a bunch of leaks. I thought now's a good time to deal with it. It's just the most common problem we have with the project is unrealistic expectation on timelines. So it's almost like, think of the time that you thought the project would take and double. It just is what it is. In order to do a bid process correctly, you want to have probably at least a month. You want to have 3 weeks to get the package out to the bidders, meet them all at the site, walk them through the project, get the bids back, do a spreadsheet, interview the contractors. And that's just one example of how, if you do a project right, it just takes time. But the bureaucracy now that's established makes it harder than ever. And then, of course, everyone forgets about the winter on these exterior jobs. And you want to keep going, but you really have to resist the temptation of pointing because, oh, look, it's 41 degrees on January 9th. Let's point. Because you will regret it very soon thereafter. One thing I wanted to mention, because it's happening a lot to us lately on payment terms, has to do with requests for down payments. I told you I'm not a big fan of mobilization payments. I'm also not a big fan of down payments unless, again, something had to be outlaid, a large expenditure, window projects, we had to purchase the windows or boiler or elevator equipment. But the problem that I have with large down payments, we just had one happen, is unless there's a bond on the project, you have no control if you hand that money to a contractor and unfortunately he goes out of business the next day. The money's very difficult to recoup. So, I heard an inventive answer from one of the churches we worked with the other day. The contractor asked for a down payment, and the church said, well, all right, just give me a corresponding discount on the price for the down payment, and what's it worth to me, and I'll give you the down payment. To me, that was almost half there. It's like, okay, I get it, you save some money, but you still have the same risk of them going out of business. It doesn't really matter. If I hand someone $50,000 in a $500,000 contract, then he goes out of business tomorrow. Does it matter if my price was reduced to $450? Really? So what I like even better is to say, well, discount your price by the amount that it will cost to get a bond, and then I'll give you a down payment. Because otherwise the owner's just outlaying that cost for a bond, and it can be 2, 3, 4, maybe it's in 5% of the contract price, which is a lot. So I'm not a big fan of down payments. If you feel like you have, I just saw one where the contractor was financing a lot of the work, so that gave him a little more control over the situation to get a down payment because the owner needs the funding. Even in those cases, make sure when you give a down payment that that money goes right against the first work that's done. Meaning we want to reset that relationship back to the owner is in control of the payments. And that means if the contractor's done 50% of the work, he then bills 50% of the work. Rand ideally will certify 50% of the work, and you pay him 50% minus 10% retainage. So he's done 50%, you paid him 40%. So the sooner you can reset that relationship from he has 10% of my money and he hasn't done anything to he's done 50% of the work, I've only paid him for 40, the better. And what you don't want to see is give me a third down, a third when I'm half done, and then a third when I'm substantially complete. Because now you are never ahead. He is always ahead. And if he's ahead of you, that means he can walk away at any time and have money in his pocket, right? So I'm not saying this like I'm very distrustful of contractors or I'm the enemy of contractors. I just don't like when it's set up in a way where the owner is at a disadvantage when unforeseen things may happen. All right? I told Margie I'd talk about this for she wanted me to talk for 10 or 15 minutes. I told her I could talk for 1,000 minutes on this. So I will stop at an unnatural segue point here, and I think we have follow-up later. Thanks, everyone.
Well, it was excellent. Thank you.